The Pretoria High Court declared that President Cyril Ramaphosa made a rational and reasonable decision to await the outcome of Public Enterprises Minister Pravin Gordhan's judicial review. The public protector had instructed the President to discipline Gordhan. Advocate Busisiswe Mkhwebane found that Gordhan was guilty of maladministration for approving the early pension payout of former SARS Deputy Commissioner Ivan Pillay. The judge found that Mkhwebane is taking the case personally and that she is inconsistent with the implementation of her remedial actions. Well, joining me now is Justin Ramages, an attorney at TRG Attorneys. Justin, good evening. Thank you very much indeed for your time tonight.
Thank you for having me.
Firstly, almost every lawyer I heard, all the legal commentary before this case, suggested that this was the way that the court would go, that the judge would go this way. Were you one of those lawyers? Are you surprised by what happened today?
Not at all. I think the recipe has been set out quite nicely. We have a history of decisions trying to suspend the remedial action. So this doesn't come as any surprise. I guess in terms of the approach, in terms of her application of the law, obviously it's a bespoke case. So again, she's found to have misapplied the law, or the facts are not inconsistent with what she's saying, and there's a number of aspects that is just poorly thought out.
The judge actually used this phrase. I don't think I've seen this in a judgment before. She used this phrase, mind-boggling.
Sure.
And she suggested that it was mind-boggling that the public protector actually brought this case. And what she said about it specifically was that she opposed this application.
Sure. What
does that tell us about what the judge thinks?
So if we take a step back to the last judgment where the public protector's position was, look, if her indignity wasn't impaired, she wouldn't have opposed the application. But as soon as it's Pravin Gordhan, there seems to be this approach where she'll contest it, or oppose it rather, in this setting. So it's difficult to understand, looking at her case and a position put forward, why she decided to oppose this application. And that's why the judge, looking at the facts, the surrounding circumstances, the application of the law, again, we find that she is wanting.
I mean, this is an issue that's been canvassed several times because it relates to all of these cases. In the past, as I understand it, what happened was that if there was a decision, if the public protector made a finding and said that remedial action had to be implemented, and then that finding was challenged by the person whom the finding was against, the remedial action was stayed at that point. This time, it seems the public protector is insisting on remedial action being implemented, even though there's still a court challenge. I mean, this doesn't seem to have been what's happened in the past.
So what we have is the OTA decision, and coupled on with the EFF and the DA decision, where the court actually came back and they said, listen, you can't ignore remedial action, it needs to be implemented. But what we're seeing in these cases, which is unique, is that she's telling the president, please apply my remedial actions and findings, implemented, but not setting a timetable. All of a sudden, there's a 30-day period in which you need to implement it. So what's happening is the court case cannot run. We can't see what the appropriate decision should be in terms of law, and so the president is forced to suspend to apply to suspend the recommendation and the findings pending the actual finding of the actual dispute.
So, I mean, that case, that will continue, so the actual challenge, and there's several of them in the works now around her decisions, but on this case, how does it run when you have all of these interim court applications at the same time? So if, for example, there's a finding against me, and so then, there's an interim action where I try and stay the finding or stay the remedial action, does that halt or slow down in any way the progress of the main case, which would be the challenge?
I think it's giving the main case the opportunity to be ventilated in open court, the judge to apply its mind to it, look at the applicable facts and law, and decide. So when you're having, and the only reason they're applying for this is this 30-day accelerated, all of a sudden there's this constitutional crisis that is pending and imminent, and we got to apply for this application to suspend proceedings. So ordinarily what would happen is you'd let the matter run, the court would make a decision, the person instructed to make the findings and the remedial action would have the opportunity to apply his mind and take the particular decision. All of a sudden we're seeing the president, in this example, being put under pressure to implement findings pending the final review. And I think that is in poor taste and poor application of the law.
You used the word bespoke earlier. In other words, each case must be settled by itself. You mustn't take into account, in a criminal case, criminal conviction, previous convictions, for example. So presumably then, each application, I mean, we could have another whole flurry of these things, and we could follow the same pattern for quite some time, and no one case affects the other.
Sure, that's correct. But what we're seeing here is there is, if I was the advising the public protector, and I would choose a different approach. I mean, we've had several approaches where she's had the opportunity to oppose the application. They always have the same ingredients in order to perform, and every time they found to suspend the recommendations and the findings, and every time it comes back and there's commentary on the performance of her office. And I think she should look, if she believes and stand behind a recommendation and findings, let it run. What's the urgency?
The EFF, the Economic Freedom Fighters, they're a party in this case on the side of the Public Protector. They say they're going to appeal the ruling. The Public Protector's Office, the head of legal for the legal affairs for the Public Protector's Office was at court today. He suggested they'll sort of give the judgment a proper deep reading before they make a decision. Do you think that a judge will actually overturn a ruling like this? The EFF was using quite strong language about it.
Sure, and look, that's their prerogative as a litigant in a dispute. And it also sounds like sour grapes. We've lost. The one version is the Public Protector will study the judgment comprehensively to find if there's any holes and oppose it. The EFF is obviously going to take the constitutional route. And one wonders what would happen once you put it in front of the apex court and they come back and they agree with the judge, then what does that say for the judge or the Public Protector? Because the Constitutional Court has already decided in a previous matter that she hasn't applied a mind. There's inherently biased action. What does that say?
If the Constitutional Court made a ruling on this case, which is around a sort of interim application, it would then be case law. It would be precedent. It could stop all of the other cases, depending which way it goes.
Sure. So, or what could happen is you have a history of the Public Protector always getting involved in Pravin Gordhan's cases, and they might see her as a vexatious litigant and try and stop her from engaging in strange litigation.
The Economic Freedom Fighters today has made several comments about this. They strongly criticised the ruling. They strongly criticised the judge. At one point, one of their leaders said that she seemed unable to read her own judgment. There was another comment that she doesn't seem to inspire confidence. How do you think judges are looking at that tonight over their glass of tea this evening?
I think it's fair. It's a nice opportunity where judges perform their craft in front of a wide audience, and we're allowed to criticize the judge in terms of her performance. I don't think they have a basis on law to criticize the judgment and the ruling. As far as reading her judgment, I don't understand what that is trying to do. It seems like the EFF, on the one hand, we should respect the dignity of the Public Protector's Office. Then why not extend the same respect to the Office of the Judiciary?
All right, Justin Ramages, thank you very much indeed, an attorney at TRG Attorneys.